mode.
Good afternoon, everyone around Australia. Welcome to this webinar from ESS BIZTOOLS on the Personal Property Securities Act and the Personal Property Securities Register. My name's Peter Towers. I'm the Managing Director of ESS BIZTOOLS. I hope you're having a wonderful day wherever you are around Australia. My apologies in advance. My voice is not the best today. I'm suffering from sinus, so hopefully you can still hear me loud and clear. If you have any questions during the webinar, would you mind typing them in and in webinar jargon raising your hand, and I will answer the questions towards the end of the webinar. Welcome in particular to our Western Australian members and colleagues in the accounting profession. We deliberately set this webinar at this time, hoping that you would be able to attend, so we're pleased to see quite a number of you in attendance. We are recording the webinar, and you will be able to access it on YouTube in about 48 hours' time, so you don't really have to sit there and take enormous quantities of notes if you don't want to. We are sending the webinar link to you. Millions of dollars have already been lost by businesses caused by ignorance and not registering on the Personal Property Securities Register. Legal action has been commenced against an accountant claiming that no information on the PPSR had been distributed to the client. That's the client's claim. So we've got some really changing circumstances that have emerged out of this legislation. Legislation that I might add many small businesses are ignorant of, and many accountants do not appear to have any detailed knowledge on. And the biggest challenge of all is that title is no longer king. Just because your client paid for something doesn't mean that they can keep it in their possession under this legislation, unless your client has taken steps to adequately protect their position on the Personal Property Securities Register. And that is the big challenge, adequately protecting your client's position on the Personal Property Securities Register. Now let's have a look at the definition. Personal property is all forms of property other than real estate under this legislation. I think one of the real problems with this legislation, and there are a number of them from a small medium enterprise point of view, is the name itself. I've talked to a number of accountants and asked them what they think personal property is, or they've rung me and said, why are we concentrating on it within ESS BIZTOOLS? And I've asked them what they think the personal property legislation applies to, and they've probably said, well, personal property is my golf clubs and my tennis racket. Well, unfortunately, it's not. It's business assets, all property other than real estate. So it covers loans, it covers intellectual property, it covers debtors, it covers sales of stock for inventory purposes. It covers sale or supply of product on a consignment basis. It's very wide. We've developed a Personal Property Securities Register due diligence review to assist accountants and advisors to review your client systems. So there are step-by-step procedures, videos, articles, checklists and forms to assist accountants to undertake a due diligence review of what is happening within their clients. And within the system, we have included some papers which we have written on the Personal Property Securities Register and various aspects of it. Now, you could probably write 100 papers on this legislation. It incorporates 70 Acts of Parliament that were previously in existence in Australia in the federal and state and territory spheres. And it covers very closely the legislation that was introduced into New Zealand, but New Zealand obviously didn't have to worry about states because they've only got one parliament in New Zealand. And I understand there is similar legislation that's been enacted in Canada and in parts of the USA. Nevertheless, there is still great confusion in Australia as to who this legislation applies to. Within our system, we've prepared some articles that our subscribers can make available to their clients, and we might just have a look at a couple of those. We'll just go out of the show for a minute, and we will this is our product on the Personal Properties Securities Register. We'll just bring it up onto the screen. And I'll just make that a little bit bigger so you can read it. The system is controlled by the procedure control form. Within ESS BIZTOOLS, we have 16 other products that we have developed, and they are each controlled by a control form to guide an accountant through the various processes that are needed to review what is we believe an appropriate approach to undertake a due diligence review. So you can click on to the papers that I referred to a little earlier. There is a form which will assist you to prepare a quotation and plan the work. And then there are various articles, and it's the articles that I was wanting to bring up and show you at this stage. So if you wanted to show your client frequently asked questions and answers relative to the Personal Property Securities Register, you have a form like this. Now you would be able to badge this with your name and address at the top of those double lines. That's the purpose of them. And the form goes through and looks at some of the questions and answers to those questions that many people in small business, and not an insignificant number of accountants, are asking. One of the big things, as you can see in that question number 2, and I think one of the reasons there's a lot of confusion about this whole legislation, is that registration is voluntary. There's no compulsion, but it's a bit like going through your business life without any insurance policies. You don't have to have insurance, but it's normally considered fairly advisable to do so. And as most of you undoubtedly conduct some risk analysis of your clients, looking at their insurance covers each year, their key man cover, their share buyback cover, their fire and general insurance covers, we believe it is just as important for an accountant to be sitting down and asking some very pertinent questions concerning a client's level of preparation to protect themselves under this legislation. So there's some of the questions that you could look at in that area to satisfy yourself that you can answer some questions for your client. We also have the PPSR myths. There are a number of myths, and we've been able to summarize 10 of them that you could make available to your client to hopefully to undertake some reviews to look at this legislation. Okay, what we're going to do now is go back to the PowerPoints, and we'll continue on. There is a video which we have linked to on the PPSR, which is very good. It wasn't there when the system first started, but the people responsible for the administration of the Personal Property Securities Register have now included it. So many of you are probably saying, well, where do we start on this? And why is it at our responsibility? Why are ESS running this webinar and talking about accountants' responsibilities? Well, there's no doubt there's shared responsibilities. Virtually every one of your clients will need to see a commercial lawyer to make sure they have a correct retention of title clause drafted, which should be drafted after the 31st of January 2012 so that it complies with the requirements of the PPSR. And also they'll need a terms of trade agreement. Now, some of your clients will need more than one terms of trade agreement for the different arrangements they've entered into with different customers. And in some instances, they'll need a different terms of trade agreement for the same customer. For argument's sake, if they're supplying ingredients to a customer's business, and that's all their terms of trade agreement refers to, and then they decide to supply on a lease or consignment basis articles such as cafe furniture or a coffee making machine, for argument's sake, that is something that if they had decided that they should be protected under this legislation, they will probably need a separate terms of trade agreement. I'll just go back. Sorry, jumped ahead. The drafting of a retention of title clause and the terms of trade agreement are only the beginning of this whole process. Unfortunately, many people believe that this is the end of the process. It is not. This legislation is very complicated, and in my opinion, the responsibility then passes to the SME's accountant to ensure an appropriate system is introduced within the SME's business to safeguard the business's assets. I've worked with hundreds of solicitors in my career. I can't think of more than one or two of those solicitors, great legal people as they were, who would go out to their clients' small business premises and sit down and clearly track through all of the transactions that were happening in that business to make sure that the client was appropriately protected. I think the commercial solicitor will be saying, and indeed the ones I've talked to, is that's accountants' work. So where you have to start here is, do your clients have a system? Now, one of the problems with all this is when the GST was introduced, seems like a lifetime ago now, but it wasn't that far ago, the Liberal government at the time, under Mr. Howard, spent millions of dollars in educating businesses as to how GST should operate, both large and small. Unfortunately, neither the previous Labor government nor the current Liberal government in Canberra have seen fit to finance a major education campaign for businesses, especially small businesses, on the operations of the Personal Property Securities Act. There was little chance of the GST sending a business broke, but it's a real possibility that it could be the fate of a business for not complying with the requirements of the Personal Property Securities Act. You wouldn't want that to happen to one of your clients, would you? We've got a comment then as the trusted advisor. Shouldn't you assist your clients in a risk management review to make sure that they have properly considered all of the potential risks? We believe that accountants do have that responsibility to undertake a due diligence review of your clients, to advise them on the implementation of appropriate systems, to ensure that the client has adequate protection from this legislation. So what type of transactions can be caught under this legislation? Well, some of them are sale of goods under the retention of title clauses. You've probably all heard of Ramalpa. It continues under this legislation and in some respects has been tightened or improved. Supply of goods on consignment, you can get a special protection for them. But one of the big issues is goods stored on someone else's possession. Half the court cases in Australia and New Zealand have been over where assets are placed when an insolvency event has occurred. Goods were stored in someone else's possession. Goods attached to other goods. Now, this is a very important area because there was previously no protection for accessions, as the technical jargon is. And this could relate to a steel fabricator. It makes a set of steps that have to go to a mine somewhere and be attached to equipment that's already in situ. There's no serial number on this equipment. It loses the ability to be repossessed because it's been attached to something else. But your client can gain some protection under this legislation. That's one of the, I think, few benefits of this legislation for SMEs. I've trouble seeing too many. I really suspect this legislation has been brought in at the request of big banks who seem to have covered themselves every way you turn. We can have protection for mixed goods. You might have a client that supplies ingredients to a pastry cook type business, fruits, flour, yeast, all those type of things might be supplied by different businesses. And then they're getting mixed into new products and then getting sold. Well, the PPSR, another good point of it, does allow that to be traced through, and your client could get some protection if they're suppliers. Motor vehicles. We'll talk more about motor vehicles and equipment renters in a moment. Equipment renters as an industry group have been one of the big losers out of this legislation so far. Not enormous amounts from what the feedback I've been getting, but amounts varying from 20 to 30,000 to up around 140,000. That's a lot of money. And for some small businesses, it could be survival or failure is built around those figures. Also included in all this is motor vehicle leases, and we'll talk about them in a moment because there's a number of days come into play. Rental of plant and equipment, debtors, livestock on adjustment. When you think about, I talked a moment ago about assets being on someone else's property. That's exactly what happens on livestock on adjustment. Unfortunately, there are major droughts in most of Australia at present. There's a very large movement of cattle occurring to move them onto properties that have a bit of grass left. But unfortunately, there's also been a large number of property foreclosures in recent times. Just because someone's got grass on their land doesn't mean they're going to escape a secured creditor appointing a liquidator or a receiver. And when that happens, this legislation can be disastrous for the owner of the livestock that are registered there, unless the owner has registered their cattle on the Personal Property Securities Register. Farmers' crops can get some benefits under this legislation. Another area that's caused a lot of anxiety, and there's been a couple of court skirmishes, involves tradesmen's tools on building sites, scaffolding, formwork. One case in North Queensland involved $1 million worth of that gear and fell into difficulty under this legislation. Boats, aircraft, and a business that supplies feed for livestock is able to get some special protection under this legislation. And you see why I'm suggesting that the average commercial solicitor might not get their head around all these things, because they probably don't know this is what the client does in their business. They might have half a dozen of these type of activities occurring. Let's move on. Seed fertilizers, pest controls for crops can also be protected. Artwork and sculptures. There was a famous case in Auckland in New Zealand. New Zealand's had this legislation since 2002. A major gallery had a liquidator appointed. There was a rush on it in Queen Street, Auckland, with various artists and painters, etc., were going back in to try to claim their sculptures and paintings. And there were security guards there that wouldn't let them take them. They had placed those goods there on consignment. and it was up to them to have protected them by registering on the PPSR. Most of them hadn't. Loans, even loans to associated entities, can fall foul of this legislation. This gets back to service company arrangements. Indeed, there was a case in Queensland of Caterpillar tractors, bulldozers, etc., that were on a site in the Northern Territory that were being hired from one company, the property-owning company within the group, to another trading entity within that group. I don't know whether someone forgot that the trading entity had borrowed money from a bank and therefore had a secured creditor. They hadn't registered their Caterpillar equipment, which incidentally was worth $2.2 million on the register, and a liquidator was appointed. The liquidator, as all liquidators do, some of you have probably done liquidation work, went ahead and did a stock take of what he now had in his possession, and he had all this equipment. Went to the register and found that it hadn't been registered, so he registered it, and then went to the Queensland Supreme Court and got their ruling that he was free to sell it for the benefit of the secured creditor. That could have all been overcome by the payment of probably about $8 to get a registration on the register, which would have covered 7 years. Pretty cheap insurance. Would you want to be sitting there talking to your client about this as a post-event? I certainly wouldn't. Intellectual properties can also be caught up in this legislation. Company A owns the intellectual property, enters into an agreement with Company B to market and sell it and have full possession of it. And along the way, Company B has borrowings and a secured creditor arrangement through a banker, and suddenly the company that owns the intellectual property could miss out. And think about the situation when you're leasing premises. Aren't you storing goods on someone else's premises? Most new leases are probably covering the period when you're leasing and paying your rent. But what happens at the end of the lease if your client continues in occupation, even with obviously with the agreement of the landlord, for a period of time, and then something happens to the landlord? Those assets that are still sitting on that property could potentially be at great risk because they're assets on someone else's property. When the government introduced this legislation, which took them about 4 years and cost $47 million to set up the registry, which was originally estimated to cost $4.5 million, they obviously assumed that every business person would study the legislation and understand how it worked and would lodge the required registrations to protect their interests. What a beautiful world if that happened all the time. In theory, this works fine. However, in practice, the amalgamation of 60 to 70 acts of Parliament from Commonwealth, state and territories has caused a lot of confusion. This can only be overcome through a methodical approach to conducting an individual due diligence review for each of your individual clients' businesses to see what they should be covered for. So we're going to go to another one of our key forms in our due diligence review document in a moment, which is going to look at how we believe you should go through this review process. Because what we've listed on the screen there, and we'll go to the next one, is a whole range of assets that could be covered under this legislation. And we've got another screen for you to look at yet too. So there's a whole range of items that could be covered. So we'll just go back and have a look at that form. So we're now going back to our control form. And I'm going to go to what we call our work checklist. For those of you who clicked on a bit late, my apologies for my very wonky voice today. I have sinus, and I hope it's not too rough, the other end of this, listening to it. Okay, so this is the form. You would badge it above the double lines with your name, logo, details. Obviously identify which client you're working on. And then you could use this form to work through and look at the various configurations that can occur for some of these items. Let's look at stock of goods. Now, stock that's on your own premises, you've really got no problems with if you own it. But if it's on leased property or someone else's property, or it's on various premises, you potentially got problems with that. We believe you need to sit down and have that conversation with your client. Where is the stock? More particularly if they're supplying consignment stock to someone. Again, when it's on their own premises, no problem. But once it gets out and starts moving around to other person's premises, there's real issues. The same thing happens with demonstration stock. Can happen also to produce for grain in grain storage and so on. So what our preference is that you're using a form like this to identify where things are, so that you're leading to a case of saying to your client, well, perhaps you should have covered this, or you should cover this. Let's look at some of the other things on livestock. Livestock's a big area because of livestock on adjustment. We've included thoroughbred horses. A few people have asked us why. Well, the main reason is there's been a very significant court case in New Zealand where a syndicate that owned a stallion that was worth $2 million, and it was leased out for breeding purposes to a separate farm entity, lost the control of that horse. It was able to be sold off by the liquidator. The case went to the full court, or the High Court of New Zealand, and that's what they decided. And the Australian courts are following the precedents that have been established by the New Zealand courts, because this legislation is very similar, virtually the same as the New Zealand one. So crops can also be. So you need to be able to work through and start looking at the various assets. What about your goods? Are goods left in someone else's possession? Are they goods sold on your behalf by someone else? Are they attached to other goods? What I was referring to before with the steel fabricator. Are they mixed goods? And so on. What about artist works? Where are they? Plant and equipment. Now, plant and equipment's got some real separate concerns if it's rented to someone. If it hasn't got a serial number, if it's rented for more than 12 months, it needs to be protected. It can be protected under this legislation. If you haven't done so, you don't get a priority protection. But one of the real problems, I believe, in this whole legislation is we have this terminology called indefinite period. So if a lease is for up to 1 year, you really don't have to worry about that asset on the Personal Property Securities Register. If it's up to 1 year and is automatically renewable, you need to worry. If you want to protect it, you need to register it. And if it's for a term of more than 1 year, you need to protect it, or to think about protecting it. Obviously, all this is voluntary. But the area people seem to be forgetting about is indefinite period. Now, an indefinite period might only be 10 days, or it could be 9 months. But if something is leased or rented on an indefinite period and you want protection, your client wants to protect themselves, then it needs to be registered on the register. And that is one of the areas where a number of businesses have come unstuck. They forgot about indefinite period. Motor vehicles. Now, motor vehicles and any other item like aeroplanes and boats that have serial numbers, the period of time we then talk about is up to 90 days. Up to 90 days. Up to 90 days automatically renewable, and more than 90 days. Now, up to 90 days, you don't have to worry, but if you want to protect and your lease is up to 90, automatically renewable, or over 90 days, if your client's got those sort of leases and they want to protect themselves, they have to register. But they also have to register if they want to protect themselves on leases of motor vehicles, boats, aircraft for an indefinite period. And it was in this whole rental space that many of people operating in the rental industry have got into difficulties through this legislation. Our form goes on then to start looking at boats and watercraft. It's very extensive, and it's deliberately so, because you might have to sit down and have this conversation with your client to make sure that everything has been looked at and thought about. And if the client's going to make a decision that they don't need to cover something, that's okay, but I'd be making sure I write a file note and confirm it to the client that they've decided not to do anything about this. There are 2 accounting firms being sued around Australia, I understand, from disgruntled clients who believe that they should have been more appropriately advised by accountants under this legislation. How many of your clients can tell you who their solicitors are? I've been asking clients for years to tell me who their solicitors are, and invariably I get told they haven't got one, or they had someone acted for them in an accident 10 years ago or 15 years ago in their divorce. A lot of small businesses don't relate to a legal firm as being their ongoing solicitors. And for that reason, they may not have thought, even though you might have suggested to them to go off and see a solicitor, they probably don't know where to go. And obviously solicitors come in all shapes and sizes these days. I'm stressing the word commercial solicitor. So this form goes on and looks at the various questions. Debtors is the next area to go into. So what we'll do is go back to our PowerPoints. I get them. Get out of the way. So we think the system that you need to be looking at is developing a customized system for individual clients. It will not be the same for every client. There might be great similarities, especially in similar businesses. But it's looking at going through and working through a procedure control form for each client, looking at the retention of title and terms of trade agreement, and looking at some of the risks that we've summarized there that your client may well be exposed to, and having a particularly close look at this question of renting, leasing, or storing assets on someone else's premises. It's become a real troublesome area. So our system is making sure that the client then follows through and makes sure that the terms of trade agreement have been signed by the customer, because that's a very basic requirement of this legislation. You can't register something unless the client signed it. And if the client's going to refuse to sign it, or the customer of your client, then I think the advice to your client should be, well, you might look at finding another customer. There must be something wrong with these people. There then needs to be a financing statement prepared, because that's the document that is in fact the basis for the registration process. There's another term that you'll find if you start delving into this legislation, the Purchase Money Security Interest, PMSI. Now, it's a very important document that you can get registration for, which has got a very high priority. It doesn't win in every case, but it's far better than just being an unsecured type of business. And then you're able to verify the statement. And there's specific items for licenses and trademarks, intellectual properties, etc. We've developed some specific forms for individual businesses. So at this stage, we might just go back onto our forms. So that's where we were at BAS 1645 when we're going through looking at all that information. And what we're going to do now is just move through some of these forms. We think it's very important that your customer, your client, undertakes a due diligence review of their customers. So this is what this form does. Because I've said a couple of times, registration on this register is voluntary. Now, if your client's dealing with the government, you probably don't have to worry about registering your arrangements as long as you're doing directly with the government. But just make sure you're not dealing with some intermediary organisation that's not owned by the government. So our suggestion is that you need to be establishing with your client what level of exposure they are prepared to accommodate and lose if something goes wrong. Now, this might be in the debtor's account, and then we've got a separate form which is looking at the value of property. Now, for some of your clients, $5,000 might be a significant amount that they want protection for, and for others it could be $50,000 or even $100,000. So it's going to vary on each individual case as you go through and try to give them advice on what sort of transactions they might need to cover for. Some people say to me, oh, well, if they're dealing with public companies, we won't worry. Well, have a look in the newspapers and have a look at how many public companies have gone into liquidation in the last couple of years. There's been quite a few. I bet you some of the people who are dealing with them, we're going to refer to one of them in a moment, would have liked to have been able to redo that whole process. So there's a form which will assist you to go through with the client and try to establish at what level they're going to be taking cover. And when you're looking at trading debts, perhaps you've got to multiply the monthly exposure by 3 because they might be 3 months outstanding when the problem occurs. So that then we're able to finalise what the terms of trade agreement are going to be for a particular customer. Then there's the form which will guide you through to make sure that the terms of trade agreement have been sent to the customer's signed it, sent it back, and you're then able to complete, or your client's able to complete the financing statement so they can make the entry onto the register. Another item to look at then is these assets that you might have on someone else's property. What are they worth? How much is your client prepared to lose? If the tractor's only worth $10,000, do they accept that? But if it's worth $50,000, is it something they want to protect? So this questionnaire, hopefully this form, will help you go through and undertake that review with them, so you can ascertain where things were. It's an interesting question to say to your customer or your client, where were all your assets last night? And just make them sit and think and say, geez, now you're not necessarily in problems if something was just left somewhere, unless it was for an indefinite period on someone's site last night, but it could give you an indication that there's very valuable assets being parked or stored all around the place that could lead to a problem. So we then have the form which will help you determine the terms of trade financing statement and to track through that everything's happened with your client that should have happened, that you've got the verification token, you've recorded all the information you need to make sure you're getting. And then you're able to prepare the financing statement and the PMSI. Now, we haven't got time to go through all these sorts of things, but they are all very important parts of this process of ensuring that everything is appropriately protected. And we're now starting to look at some of these things about loans and even statutory fishing rights, which I haven't come across anyone that's got a particular problem. We've then developed some forms to assist you in particular industries, which drags out some of the more frequently asked questions within a particular industry. So this is a retail business. This is saying that you could have issues relative to supplying goods to customers, supplying goods on consignment to someone else, storing goods and equipment on someone else's property or warehouse, leasing of business premises, potential problems when the lease ends and you're still in occupancy of those premises. So those sort of forms are there. There is forms to assist you in 16 different industries, and we will be adding a few others. There's some of them there that will help you go through and look at those particular industries. Under this legislation, and we'll just go back to the PowerPoint slides now. Under this legislation, there's been a number of court cases already in Australia. In each case, the liquidator or receiver acting for a secured creditor has won the case against the business that actually paid for an asset, because basically the business, the one that had paid for an asset, had not registered their interest on the PPSR. Some of you may be aware of the ongoing issue relative to the Forge Group. There was an article in the Sydney Morning Herald a few weeks ago, 27th of July, which indicated that the receiver of the Forge Group is going to go to the New South Wales Supreme Court to apply for the court's approval for the receiver to sell $50 million worth of assets that are situated on the land owned by the Forge Group that were being rented to them by someone else. And that other organisation, which transpires as a Canadian corporation, had not registered their interest, it's alleged, on the PPSR. Watch this space, because this will be the biggest claim under this legislation if it's supported by the courts. I still have great difficulty in accepting how some of these things are going, and indeed how this legislation is worded and what people can lose. But that's the situation. At one of our webinars a few weeks ago, in our participants, we had a insolvency practitioner who volunteered the testimonial that's currently on the screen. As an insolvency practitioner, quite often we are faced with suppliers who have retention of title clauses in place, but are not aware of the changes in the security regime, effective in January 2012. This lack of awareness amazes me, and is predominant amongst small business. Unfortunately, the business owner generally finds out the hard way when faced with an insolvency practitioner who tells them that they no longer have title and or ownership of the goods. There is certainly an opportunity for all accountants to add further value to the relationship with their clients by conducting a PPSA review to ensure their compliance. Darren Vardy, Director, SV Partners, Specialist Accountants and Advisors. And as I indicated, Darren was participating in the webinar, made those sort of comments, and then we asked him if he would like to give us a testimonial as to why accountants should be taking a serious look at this legislation and he agreed to do so. Just to have a look at what a subscription to this product costs. The due diligence review module for PPSR is part of the gold package and silver package for members of ESS BIZTOOLS. So if you happen to be a member of any of those, and none of those people are participating, I don't think, in today's webinar, but if you were, or you decide you would like to subscribe to ESS BIZTOOLS, then you receive, as part of that subscription, your access to this system. But for anyone else, if you want to take out a subscription for 12 months, 24/7 access, the subscription is $350 plus GST. So what we might see now, if anyone has got any questions on anything we've discussed or any other issue relating to, and I see we've got a couple here, so we'll just go back and the question is, what if and this is a very good question, what if the bank has already lodged a PPSR on an item of equipment? Well, the key thing is, in part of this process, is to do your due diligence on the registrations when your clients decided they're going to deal with a particular customer. And if you find that the item you're wanting to protect, in effect, is already covered, then perhaps your client has got to rethink the process or get some special dispensation from both their customer and the secured creditor. This is not foolproof that a PMSI is a foolproof protection, but it's far better than not having any. And there are some cases where the secured creditor will still trump a individual supplier, but you should be able to find that out before the supply is made and then make the determination. As I've said a couple of times, registration onto this system is voluntary, but your client may well decide they're not going to supply those goods to that particular customer because they can't get any better protection. That area is a legal question, and if you're looking at that very seriously with your clients, it's part of the discussion that you should be having, or you're making sure your client has, with their legal advisor to make sure they clearly understand how all this works. The other big problem a lot of people are going to have is this can be a real sleeper. It might be years or never that one of your clients has a problem under this legislation, but it could come back to bite someone very badly in 7, 8, 9, 10 years' time, who have just merrily gone along their business ignoring this legislation, and then suddenly something goes wrong and they've left a very valuable asset on someone else's property under some agreement that hasn't been registered, or something else has gone wrong. E.g., that situation of $50 million. Many of your clients probably won't have 4 turbines worth $50 million, but they could have assets worth $2 million, like those tractors and bulldozers from QES that have been forfeited to a liquidator. If any of you think of any other questions later on, we're quite happy for you to contact us because we're still learning on this legislation as well. The whole purpose of this webinar and the product we've developed is trying to give accountants an internal control system to utilize so that you can start having that very important conversation with your clients to ensure that they have really considered the risks if they've decided not to cover anything under this legislation, or if they've decided to cover some things or up to certain amounts of money, to ensure that the system is appropriately being operated to ensure that that happens. I'll just check that. There's a question, can you lodge a PPSR over an asset that, if that asset already has a PPSR registered therefore and ranks second? Well, you're coming in virtually as an unsecured creditor then, or you could be. It might be far better to try to negotiate. It's probably a question that you should be getting your client to put to their solicitor when you're planning what goes on in their particular business operations. And if that was a big issue and involved a lot of money, I think your client should be thinking very seriously about how they structure that particular transaction with that customer. That's all the questions we've got. Thank you very much for participating in this webinar today. We would love to hear from you and welcome you as subscribers to either the total ESS BIZTOOLS products or to the PPSR due diligence register. Thank you for participating. Have a wonderful day. Goodbye.